Hello, everyone. Welcome to Don't Get Sued by Your Title. Imagine, imagine this. You've just finished your masterpiece. It could be a novel, a screenplay, or a pilot for a new web series. You've come up with the perfect title. It's catchy. It's yours. But a few weeks before launch, you get a letter. It's from a lawyer. It turns out someone else used a similar title for a project 3 years ago, and now they are claiming you are infringing on their rights. Suddenly, your project is in jeopardy. This isn't a rare horror story, it's a real world risk that creators face every day. Why? Because the rules around who owns a title are some of the most misunderstood in the entire world of intellectual property. Welcome to Title Fights, the podcast that demystifies the legal landscape for creative professionals. I am your host, Daniel Castillejos, and today we're tackling that $1 million question. Can you actually protect the title of your work? Well, we'll start by debunking a huge myth in the United States. Then, we'll take a global tour to see how the rules changed dramatically in Mexico, the UK, Canada, and the European Union. By the end of this episode, you'll have a clear, practical guide to protecting your work and avoiding those dread ceased and desist letters. The Great Misconception. All right, let's start in the United States. Most people assume that if you create a work, the title is protected by copyright, just like the story of the song itself. Well, that assumption is completely 100% wrong. The US Copyright Office is very clear on these titles names, and other short phrases simply don't have enough creativity to qualify for a copyright protection. Copyright is designed to protect the expression of an idea, the thousands of words in your novel, the specific notes in your melody, not the short phrase you use to label it. So, if copyright doesn't protect titles, why do we see big Hollywood studios suing each other over them? Well, the real battleground isn't copyright, it is actually trademark law. A trademark's job is to prevent confusion in the marketplace by identifying the source of a product. It's about making sure consumers don't accidentally buy a generic soda when they wanted a Coca Cola. In the creative world, it's about making sure the audience doesn't think your new movie is a sequel to a blockbuster hit just because the titles are similar. And here's where it gets even more specific. US trademark law makes a huge distinction between the title of a single standalone work and the title of a series. A single work title like the book The Tipping Point or the movie Inception is generally not eligible for trademark registration. The law sees that title is merely descriptive. It describes the product itself. But a serious title like Harry Potter or The Hunger Games can be trademarked. Why? Because that title acts as a brand. When you see Harry Potter, you know it comes from a specific creative universe. The series title identifies the source, while the individual book titles, like And the Sorcerer's Stone, are just descriptive subtitles. So, what about your single work title? Does it have any protection at all? Well, yes, but you have to earn it the hard way through something called secondary meaning. Secondary meaning is a legal concept that means your title has become so famous through marketing, sales, and media coverage that the public no longer thinks of the words themselves, but immediately associates them with your specific work from a single source. Think of a title like Jaws. It's a common word, but in the context of media, it has a powerful secondary meaning. Proving this is incredibly difficult and expensive. You need evidence of massive commercial success. This creates a paradox. A new title has almost no protection when it's most vulnerable. It only becomes legally defensible after it's already a huge hit. But wait a minute. Now, it's crucial to remember that intellectual property law is territorial. The rules we just discussed for the US are not universal. Let's hop across the border to Mexico, where the approach is completely different. In Mexico, in a major departure of the US model, Mexico's federal copyright law provides direct protection for titles under copyright. Article 229 of the law explicitly states that using a title in a way that induces confusion with another previously published work is a copyright infringement. This is a game changer. It means that in Mexico, you don't have to rely on complexities of trademark law to defend your title. However, this protection is not absolute, just like in the United States. Article 14 of the same law in Mexico clarifies that generic titles or common phrases are not protected. So you can't claim ownership of a title like My Story. Mexico also has a unique IP tool called the Reservation of Rights to Exclusive Use, Reserva de Derechos al Uso Exclusivo. This is a special right granted by National Copyright Institute that allows you to exclusively use titles for things like TV series, magazines, names of artistic groups, and even fictional characters. It's another powerful layer of protection specifically designed for creative works. In the United Kingdom, it's all about passing off. Now, let's cross the Atlantic. The UK system is much more aligned with the US approach. Titles are not protected by copyright. Instead, the primary legal tool is a common law concept called passing off. Passing off is exactly what it sounds like, preventing one business from passing its goods or services off as those of another. To win a passing off claim, you have to prove three things often called the classic trinity. 1. Goodwill. You must show you have a reputation in the market associated with your title. 2. Misrepresentation. You have to prove that other parties' use is a similar title is likely to deceive or confuse the public. 3. The damage. You must demonstrate that this confusion has caused or is likely to cause harm to your reputation or sales. Just like in the US, this is a high bar to clear for a new work. And for series, registering the title as a trademark is still the strongest and most straightforward form of protection. Our final stops of the tour are Canada and the European Union. You'll notice a pattern here. Canada follows the US model very closely. The Canadian Copyright Act does not protect titles. Furthermore, Canadian courts have explicitly ruled that titles of single works are descriptive and cannot be registered as trademarks. The only real exception is for series titles, which can function as a brand. The European Union is a bit more complex because it is a mix of harmonized directives and the national laws of its 27 member states. Generally, titles are not protected by copyright unless they are exceptionally original, which is rare. Protection is typically found through national trademark laws and, importantly, unfair competition laws. For example, Germany has specific laws that grant unregistered rights to titles once they are used in the market. And Spain's unfair competition laws prohibits acts of imitation that could cause confusion or exploit another's reputation. Okay, we've been all over the legal map, so what does this all mean for you, the creator? How can you navigate this complex landscape? Here is a practical 5-step action plan. Step 1. Do your homework. Before you fall in love with a title, do some searching. Check on Google, Amazon, IMDb, and the National Trademark Database so of the countries where you plan to release your work. Step 2. Analyze your title strength. Is your title generic like War Story, or is it fanciful and unique like Queertopia? Generic and descriptive titles are low risk for infringement, but they are also nearly impossible to protect. Fanciful and arbitrary titles are much more protectable, but that also means that you are at higher risk if someone else has a similar one. Step 3. Single work of a series. This is the most important strategic question, especially in the US and Canada. If you're planning a series, you have a much clearer path to trademark protection. It is a single work. Step 4. Think globally and act locally. Remember that copyright is territorial. If you're a producer in Mexico City, your title has copyright protection at home, but if you plan to distribute that work in the UK, you'll need to analyze your risk under their passing off laws. Your legal strategy must be tailored to your key market. And step 5, when in doubt, get a professional opinion. In the film industry, no major distributor will release a movie without a title report and an opinion letter. This is where a specialized firm does an exhaustive search for conflicting titles, and an entertainment lawyer writes a formal letter assessing the legal risk. While this might seem like a big step, it is the gold standard for due diligence and the best way to ensure your title is safe to use. So, there you have it. Protecting a title is far from simple. It's a complex web of copyright, trademark, and unfair competition laws that change from one country to the next. The key takeaway is this: don't leave it to chance. Proactive research and clear understanding of the rules in your specific markets are not just legal formalities, they are essential tools for protecting your creative vision. Thinking about these issues from the very beginning can save you from a world of financial and creative heartbreak down the road. Thanks for tuning into Title Fights. Join us next time as we dive into another corner of the creative legal world. Until then, create safely. My name is Daniel Castillejos. Goodbye.